Great, thank you everyone for joining. Today's webinar, whose model is it anyway? Intellectual Property 101. Like I said, must be a hot topic because we really have quite a big crowd today, and thank you everyone for joining us live. The session will be hosted by me, Yanni Fuldian from Baynes, but I guess it really is all about our guest speakers, Mark and Kesha from Andersen, who are the legal experts and who's really going to cover the intellectual property side around model ownership and so forth. So if you're new to this webinar, I know that there's a lot of people who may be here for the CPD points also. If you're new to this webinar and new to Baynes and you're not exactly sure where do we fit in and why are we facilitating such a conversation, I do want to just briefly introduce you to Baynes. So in essence, we do three main things. We're a consulting company. We mainly focus on BIM consulting, data management, CAD, CAM, and simulation. We're also very passionate about education, specifically blended learning. So we've got accredited classroom courses, virtual training. We do quite a bit of project-based training, and we also offer a self-paced online e-learning solution. And then part of the solutions, and the reason why I'm specifically talking about model management, is we do also sell and support software and hardware for a couple of leading brands like Autodesk, Leica, ClearEdge, CAD Learning, and so forth. So that's kind of Baynes in a nutshell. And we do all of this for customers in the building, civil, process plant, mining, and also manufacturing sectors. But let's have a look at today's agenda. So first of all, just to set the scene, I'm going to briefly just run through the risk management series. This webinar is part of a series, but it's luckily not exactly a series that follows on one another, so you can kind of watch episode 5 and then go back to the YouTube recordings and catch up on some of the other episodes if you've missed any of that. Just to provide a little bit more context before I hand over to Kesha and Mark, I'm just going to do a brief overview of the BIM environment. I know that there's a lot of terminology and concepts and things in the BIM environment, and I just wanted to make sure that we're all on the same page. Then I'm going to hand over to our guest speakers today as they really get to the meat of the presentation, where they'll be talking about intellectual property law, copyright, protection of your IP, and also they'll be answering some of the frequently asked questions that I know most of you will most likely have. At the end, we'll just do a quick summary and close. Now, like I mentioned, thank you to GIFA. Today's webinar has been CPD validated. Fortunately, I guess you have to actually attend the entire webinar in order to get the CPD points, so please do stay towards the end. At the end, we'll have a QR code and a link available where you can go and complete your CPD registration form, and that will then allow GIFA to issue your CPD certificates so that you can claim those CPD points. Now, from a series overview point of view, the series of webinars that we've been hosting over the last couple of months are all about BIM and technology and what kind of impact that has on risk management within the built environment. If we think about risks, there's really 4 different things that we can do. We can transfer the risk, make it someone else's problem, mitigate the risk, accept the risk and just try to get some contingency plans in place, or alternatively, we can just avoid the risk and turn down the project to change the scope. Most of the sessions and things that we are covering in this series is all about how can we mitigate the risk. Now, BIM and technology does allow different tools and workflows that help you mitigate and manage a lot of risks on projects, but we're also acknowledging the fact that with new workflows, with new tools, it also opens up some new risks that we need to consider. That is why we are talking about intellectual property today. That is why we've had a session around data security, because it helps you in a lot of ways, but there are also a couple of things that you need to consider and that you need to be ready for. So just from a series overview, what have you missed? These sessions are recorded and they are available on our YouTube channel. We did a brief kickoff of the series just to kind of set the scene a couple of months ago. We also had a session around reality capture and as-built, specifically looking at how can you make sure that you've got better context and better as-built information or a better sense of the actual reality of the project that you're going into. Then the recent collaboration with Andersen's was all about data security. We touched a little bit on the PIA Act and also a couple of things around cybersecurity that you need to consider. Today's one, which so far is a very popular one, intellectual property. Next up is all about common data environment and Autodesk Construction Cloud. I know that there's a lot of questions and a little bit of confusion around kind of the name changes and all of those types of things. So in this session, we'll both look at how it can help you mitigate risk and also some of the things that you need to consider to make sure that you're following best practice. Towards the end of the year, we're touching on information requirements. So that's things like level of detail, level of development, your EIR, all of those types of things. And then we're finalizing this series by looking at asset management and the facility management of it. Throughout the series, it is a combination of webinars and ebooks. So in some cases, you'll have a webinar with an ebook that accompanies that or touches on the same topic. Then just to make sure we're all on the same page around the BIM environment. Now, I'm guessing that if you've joined us today, that you have a fairly decent understanding of BIM and what is commonly understood as a BIM environment. But just to make 100% sure, I like to include this in almost all of my presentations, so apologies if I'm boring you, but it is important that we're all on the same page with regards to BIM. So ISO 19650 defines BIM as the use of a shared digital representation of a built asset to facilitate design, construction, and operation processes to form a reliable basis for decisions. If we look at that, one thing to remember here is it refers to built assets. So if you have joined today and you're not an architect and engineer who works on buildings, but perhaps you are more from a civil infrastructure point of view, this refers to you as well and it applies to you as well. And I think a lot of what we're covering from an IP point of view, although we're referring to Revit models, it would probably apply to you in a civil or even a process plant aspect. So just to break that down quickly, we know that it's a working process. We are going to talk a lot about Revit and Revit models today, but we know that Revit on its own or any software application on its own is not BIM. It's all about the process. A lot of this has got to do with information, getting the right information to the right people at the right time, not just adding information because you're trying to be fancy. And then also the virtual asset. So I guess from an IP and ownership and copyright point of view, it's a lot about I have this virtual asset. How can I protect this and how can I make sure that those who have access to it have the right kind of access and are doing the right kind of things. So looking at this, we know that yes, it is a process, but it's quite a bit more than just a process. It really is a way to better manage information. Now that I've briefly covered that, I know that today is all about whose model is it anyway. And I mean, you can guess where we got the inspiration for the name from, if anyone's ever watched Whose Line Is It Anyway. Now, talking about models, there's a couple of things that we need to just take into account. I do want to just go through some definitions to just make sure that we all have the same understanding of these different models. In the BIM world, there's a lot of acronyms, there's a lot of things that kind of mean the same thing, but not really. So I do want to just set the scene with us. Now, I think we're most of us on this call today are familiar with Revit models and perhaps other software. So if we're talking about models in a BIM context, we know that yes, often there's Revit models, but it's not just one, it's multiple. There's also other software involved. It could be a Navisworks model or InfraWorks or other types of specialist software. And ideally, these models also include data and documentation. So that kind of is the whole of, if we refer to Revit models or Revit model, we're talking about Revit and or other similar pieces of software, as well as the data and the documentation that is included in that model. So if I'm talking Revit model, I'm not talking about you've got a conceptual mass of one block. We're talking about kind of your BIM Revit models. Now, these things, your Revit models, other software and data and documentation, they then become the BIM model, as is commonly known in the industry. Some of you have also maybe heard the term a PIM model or an AIM or AIM model. If you're confused by this, that is why I wanted to just make sure we're all on the same page. So if you look at ISO 19650, this is how they kind of demonstrate the ideal BIM workflow through the different project stages, where you don't have information that kind of is going missing every stage of the project, but it kind of builds, so your quality of information gets more and more, ultimately to handover. And the model that exists in that project stages, so really kind of stage 0 to stage 5, is known as PIM model or a project information model. Once it is handed over and the facility management or the asset manager's client owner then uses that model in the asset life cycle, it is known as an asset information model. And I almost want to say, like, the collective word for BIM model, PIM model, and AIM model, we can just all kind of call them information models. So when we refer to as BIM model or information model, we're talking about either the model that exists in the project stage or the model that exists in the asset lifecycle stage. And these things, as we build them up, then ultimately become what we refer to as a virtual asset. So if you look at the definition that I showed earlier, which is all about it's creating a virtual asset, this is how that virtual asset kind of gets created. So for the purposes of today, when we refer to an information model or a BIM model or a Revit model, this is kind of what we are talking about. Just to look a little bit deeper into a virtual asset or that virtual model. Now, a virtual asset contains 3 things, or at least it should contain 3 things: a graphical representation, a non-graphical representation, and an auditable record. What does this mean in simpler terms? It has a graphic model, the 3D representation of what the building actually looks like. It's got the asset data. The asset data is really, this is the I in the BIM or the PIM. This is where the information comes in. The graphic model on its own is just pretty to look at, doesn't serve a hell of a lot of purpose. The asset data is really where it's at. And then obviously you need an auditable record, and that's the documentation that you get out of this. So virtual asset or information model, just for ease of understanding, your graphic model and your asset data produces the documentation. So unlike something like AutoCAD, for those who still use AutoCAD on a frequent basis, I know it's always there. It's almost like every project will have a little bit of AutoCAD on here or there. But for those who are very familiar with Revit or BIM-based workflows, you'll know that your graphical model and your asset data produces the documentation. And then that graphical model and asset data, that combination, can be seen as a database. Revit, with all of its information, or a proper BIM model, let's rather use that, can be seen as a database. Now, if we just look at these individual components, so the graphical model, the asset data, and the documentation. Graphical models, the 3D representation. Please do remember that a 3D model alone is not a BIM model. So if you just have a 3D model that looks like a desk, but it doesn't really have a lot of information in, there probably isn't a lot to protect there, because it really is just a graphical representation of something that we are all very familiar with. The asset data is the information that either sits inside of your model or that is referenced to your model. So it could be referenced to another database, but it's easily accessible through kind of a graphical model interface, if I can put it like that. And then the asset data is also where we differentiate between what is a 3D component or a family or a model and versus what is a BIM component. It's really about does this provide information to me? And again, if we look back at that earlier definition of BIM, it's not just information that's nice to have, it's all about the right information at the right time to the right people. And then documentation. I think documentation here I'm referring to your PDFs and DWGs, or your hand-drawn drawings if we're talking years and years ago. I think that traditionally architects and engineers have always produced this. This is not something that's new to anyone. And also traditionally, it's not always the case anymore, but traditionally or typically, this is what the client pays for. They pay you to go, I want you to give me the plans and the documentation in order for me to go and build my house. So traditionally, this is kind of what the client would pay you for, the concept of graphical models and asset data, and that is a newer concept, but also I mean, it's been around for for about a decade now. Then I do want to just add this in here because, like I mentioned in this risk management series, we're looking at how BIM and the use of BIM methodologies and workflows can help mitigate risks. And today we're talking about some of the risks that comes with it that you need to consider. So I do want to just mention these are all of the wonderful, great things that comes with using a virtual asset. It's easier to access and understand. So obviously, if you've got this combination of documentation, asset data, and this 3D representation, it's easier to understand. It's easier to analyze information from multiple sources, specifically talking about now when we get into that collaborative space and we're getting multiple different pieces of information together, it's easier to understand that in a virtual asset. It's definitely easier to make timely and informed decisions because, again, right information to the right people at the right time. It accurately represents the physical asset. So this is kind of the stepping stone towards a digital twin. When we're talking virtual asset or BIM model, not the same as a digital twin, but it's definitely kind of, that's phase one before you ultimately go to a digital twin. It can be used for a tool to manage an asset. So I think that's quite obvious. That's also why a lot of clients have been asking more for Revit models or BIM models because it is really useful if you're a landlord or you're managing an asset or a building. It has a currency, history, and a version that is clearly understandable. We all know that working on the correct version is like an age-old problem, and making sure that you've got that history in case anything may go wrong. It's there. I think later when I had a conversation with Kesha and Mark a while ago, people in their position quite like the idea that this has a history and a version because it's easy to see kind of the progression of something, and if anything had to go wrong, you could track that back. It's used in a collaborative manner. We understand that ultimately a virtual asset only really works if all parties involved are creating a virtual asset. It's not really as useful if you have a virtual asset because the architect gave you a virtual asset, but everything else in that building is not part of the virtual asset. Definitely reduces the risk of human error. We've seen that graphical representation as well as your asset data produces the documentation. So this produces the documentation, it reduces the risk of going to make sure that you fixed everything anywhere, and there's a certain level of intelligence that's built into this. And then obviously it makes it easier to communicate your design intent. It's easier to understand what you're trying to achieve when you are using a virtual asset or a BIM model. Now, this is also just important for me, I think, in order for us to understand the different people in the ecosystem. So when we have a look at the graphical model, the asset data, and the documentation, we have an author. The author is the person who creates this. Typically, your architects and engineers. So you would create your Revit model, you would make sure that your Revit model has the correct information, and you would produce your documentation based on that. Then we also have the owner. Now, documentation traditionally went to the owner. Recently, the owner may also be the owner of the graphical model and the asset data that's attached to that graphical model. Something just to remember here is that the asset data is often the manufacturer asset data where they are the owner. So simple example, if you're putting a Samsung TV screen in your boardroom, it is not your Samsung TV screen and it is not the owner of the boardroom Samsung TV screen. It is a Samsung TV screen. They're the manufacturer and they're the owner of that design and everything that goes into it. So keep in mind that when you are adding in that asset data, if it's a Coro brick or whatever material you're specifying, it's really the information of that specific manufacturer or owner of that building product. Then just lastly, if you're looking at this to go, oh, so many things to remember, what if I don't do this, or what if I don't do this? All three of these things, graphical model, asset data, documentation, definitely needed for effective collaboration and coordination in that project information model stages. And then also all three of these are definitely needed for further asset management, or if you wanted to do asset management based on that model and develop it further. Now, with all of this being said, there are a couple of things that we need to consider. And I think most of the Revit users on this call would agree with me that not all Revit models are created equal, or BIM models. We kind of, I'm using the term interchangeably here. So person A may have a Revit model, kind of looks nice, decent amount of information in it. But person B may have a Revit model and their families and information, asset data in other words, are quite a bit more, and it's more accurate, and it's got much higher quality in it. So to almost make this simpler, my families in Revit may look quite a bit different to your families or our models. Now, that may depend on what is required for the project, where are we in the project stages, but it is important to remember that not all BIM models are created equally, or Revit models, and some are better than others. And that is kind of leading us into that conversation. Well, if mine's better than theirs, what if they take mine? Then to build on that, we've got two people, person A or company A and company B. They're both creating a graphical model. One is creating the graphical model a little bit faster than the other. And person A creating the graphical model, they've got some asset data attached to their graphic model. So it's a version of a BIM model because it's got some information. Company B creating a similar graphical model, doing that a little bit faster. Because why? Because they've got some asset data, perhaps a little bit more, better asset data. But they're also using script or Dynamo or some macros and really well-defined Revit templates. And I think this is where a lot of the conversation that I had prior to this webinar, the reason why we thought this was a great conversation to open up came from, because we know that there's graphical model, there's asset data, there's documentation, but there are things like scripts and codes and templates and stuff like that that sits behind all of this that may give company B the upper hand or the competitive advantage over company A. And I'm hoping as I say this, you go, yes, I have that. That makes me faster, or it's helped me. And if you don't have that, I'm hoping that you're wondering, maybe I can make my modeling process a little bit faster. But now that I'm hoping that we all understand the different aspects and concepts of information models, kind of as the collective word that I want to use, and some of the things that you should maybe consider, I want to just go to a quick poll. Just want to hear a little bit from everyone on the call today. So I'm going to ask Amanda to open a poll for us. Okay, you should see the poll on your screen, and the first poll question is really about, I'm reading it here because I'm not sure which one came first. The first poll question is really about, like, what are your concerns around IP? Kind of, why are you here? What do you want to, what's the type of things that you're worried about? So, okay, the votes are coming in. I do want to allow as many of you as possible to provide answers to this, because this is something that I also find quite interesting. At the moment, other consultants using my template is coming in as the #1, followed by my client is not paying for a Revit BIM model, and then my client replicates my work and doesn't pay me for that. So I think, no, I mean, there's some people concerned about someone copies and uses my design work, but I definitely feel that it's the consultants and working with different consultants that seems to be the winner here. Okay, I see that we've got 55% voted, so I am going to just give it another 30 seconds to see if we can get some of the rest of the votes in there. To also help us inform what kind of future content we need to put out. So if everyone's concerned about that, maybe we can see how we can address that. Okay, that's still a winner. My client's not paying me for a Revit or BIM model, and my client replicates my work and does not pay me. It's actually tied at #2. Who are all of these clients who's not paying? Okay. let's see. Great, Amanda. Thank you. And let's do one more poll. The second one coming up for you shortly. Okay, so a second question is around who's ever been in trouble with IP or IP related issues. So I think this is also something interesting. Great, so far no one's had an issue, but you want to make sure that you don't ever have an issue in the future. Okay, and then quite a couple who's had some of their things used perhaps in a manner that it shouldn't have. Okay, votes are coming in quickly. Yeah, I'm glad to see that. No one's had an IP claim against them, so that's good. That's good. A couple of you think it's not a big deal. That's the collaborative spirit that we're looking for. Okay, we're almost at the 70% mark for the vote. So if you haven't, if you can quickly go and just choose your option in there, and then we'll close this poll soon. I'm looking here because I'm seeing how the results are coming in. Great. Okay. Thank you, Amanda. Okay, definitely the winner here is most of you haven't had an issue, but you would definitely like to be prepared. And I think that's a good mindset to have, you know, just to be future ready and be prepared for what to do and how to really protect yourself and be informed on the topic. Great. Okay. Thank you for that. Now that the poll's over, let's get to the real meat of the presentation, Introduction to Intellectual Property, IP law. I want to introduce you to, and I'll introduce both Mark and Kesha, and then I'll hand over to them so that they can take you through the real good stuff. So Mark Thomas is a partner at Andersen's SA dealing with commercial litigation. Mark has been specifically tasked with facilitating the establishment of the Andersen South African Intellectual Property Service offering. So he really is the expert on intellectual property, and the reason why we are collaborating with them and inviting him to inform us all on this very interesting topic. Mark's done quite a bit of different commercial and regulatory disputes, focusing and obtaining strategic outcomes, and also has worked with environmental law, competition law, intellectual property law, and also mining law. And then Mark is joined today by Kesha, should be a familiar face for some of you if you've joined any of the other webinars. Kesha is also a partner at Andersen's dealing with commercial litigation. She specializes in commercial litigation, dispute resolution, business restructuring, and also insolvency. And she's got quite a bit of experience in multiple different various industries like mining, construction, logistics, interior design, as well as manufacturing and trade. Now, before I officially hand over to Mark, I just want to quickly pop this on here. Not all questions, they can't just give you legal advice like this on a webinar. So if during the session you want to get in touch with them because you have more specific questions, contact details on the left there, or you can take your phone and scan that QR code that will provide you that will allow you to actually request contact. I will have this on again at the end, so if you don't have a chance to do this here, or maybe you go, I don't have a question right now, but towards the end you go, I need to speak to them, we will have the contact information on again. Okay, with that being said, I'm going to hand over to Mark. There you go, Mark and Kesha.
Thanks, Yanni.
That's it. Thanks, Mark. Okay, Mark, I can see your screen. Over to you guys.
Thanks, Yanni, for that introduction and presentation, and a very warm welcome to all the participants joining us today. Other than being IP experts, having looked at the answers to those polls, it seems that maybe some of you need some debt collecting done, and of course we offer that service too. I truly hope that the content that we will present will clarify and answer some questions that you may have. And it's obviously great to have kicked off with some insights into the construct and inputs required in the BIM environment. My takeaway from Yanni's presentation is that BIM and Rivet models contain a tremendous amount of information that can be transmitted quickly and easily, and that can be extracted and of course reused, which is fantastic to foster working relationships and encourage collaboration to develop a project. But in the BIM environment, the question is often posed, whose model is it anyway? So to that extent, or to some extent, we all engage with intellectual property on a daily basis and have an innate sense that the products of our minds have commercial value that we ought to be able to realize a commercial benefit from and of course protect, which is why most of you are participating today. When it comes to intellectual property, or IP as we're going to refer to it, we have to conduct an assessment of the subject matter, the different species of IP that we are dealing with. How do we identify what is our IP and what is the IP of others? And how do we protect and benefit from our IP? There really is so much that we can talk about from a legal perspective, but obviously the intention today is to provide you with very basic tools to understand, identify, and protect your IP within the BIM environment. So with that said, Mark, let's start with an overview to warm everyone up to the content before we dive into the wonderful world of BIM-specific IP considerations.
Okay, fantastic. Thanks, Kesha. So you're quite right. Leading up to today's talk, there's been quite a bit of excitement and interest. We've had a number of questions come in, which is great. I mean, IP is really one of those areas that's developing, has an international application to it. There's a value for almost everyone, architects, lawyers, the whole bunch of us. But the impression that I'm getting from some of the questions that have been posed is that it would be helpful to run through the IP legal framework before we start dealing with BIM environment specific questions. So for purposes of today, this is just a brief roadmap of what we're going to be discussing to give you an idea where we're going. We don't have many slides. We're going to be speaking about these concepts, so sharpen your pencils. But really, we're going to discuss, first of all, the legal framework from an international and local perspective. Then we're going to look at some of the commercial aspects, how to protect your IP. And then finally, we're going to get around to addressing some of the common questions of, whose model is it anyways? So let's start on our deep dive. We're going to go back 180 years to the English author Charles Dickens. He was thinking about IP and starting to realize some of its benefits. But one of the challenges that Dickens faced was that in places outside of England, there was little or no protection afforded to his works, and unauthorized copies were being made in the United States, which he received no compensation. So he jumped on the boat, went across to the States to advocate for further IP protection and the recognition of him as an author and his rights that attached to that in the States. But it wasn't all that successful. He's quite famously quoted as of writing a rather bitter letter to his friend, in which he says, "Is it tolerable that beside being robbed and rifled, an author should be forced to appear in any form, in any vulgar dress, in any atrocious company?" Now, that's quite interesting. He touches on three important concepts in IP. Firstly, there's the international aspect. Secondly, all IP rights work in the negative. They stop other people from doing certain things with your works, such as copying, adapting, and selling a work unless they're authorized to do so by license or assignment. In Dickens's case, not only was he unhappy about not receiving payments for the reproduction of his work in the States, but he was also unhappy about the manner in which his works were being reproduced and being put into any vulgar dress. Then secondly, the other thing Dickens touches on in his complaint is that IP is a bundle of rights. There might be more than one type of IP in every product. Let's think about a book for a second. There's the story itself, written by Dickens, to which he asserts a right to. Then there's the cover. Usually, if we think about some of the fiction books we see, there's a dramatic image of something on the cover, but somebody prepared that, took the picture, stuck it on, so there's a claim there. Then there's the actual shape and tactility of the book, which may also attract a design element to it. Someone might claim something unique about that design or the paper being used in the book. And then finally, there are the rights to reproduce the book, distribute the book, and sell it. And this might come with various restrictions, geographic areas distribution, minimum resale price maintenance, and those are all the IP issues that you have to deal with and grapple with. So remember, IP is a bundle of rights. You're never dealing with just one. There's likely to be several when you look at a particular aspect. But finally, some good news. The law has progressed since Dickens' time, and that was the 1840s. Okay, so now I'm just going to briefly touch on some of these international pieces of legislation that we've got. They're referred to as conventions or treaties. And the idea is that they're trying to protect your rights in foreign jurisdictions, provided that the relevant jurisdictions, so relevant countries, are members of these conventions. I won't go into too much detail. I do realize it's midday on Friday. You're all going to be out of here in 10 minutes if I start diving into some of the technical aspects of these, but I'll just briefly touch on them. So the first one that we come across a lot is the Paris Convention for the Protection of Industrial Property, and this relates mostly to trademarks. The second one is the Berne Convention for the Protection of Literary and Artistic Works. This deals a lot with copyright, so we'll just put a flag in that one for later. And then finally, we get the trade-related aspects of intellectual property rights. This you'll hear lawyers talking or referring to as TRIPS. The TRIPS agreement tries to promote trade between member states, relieve some of the tensions and disputes around IP between the states and the foreign jurisdictions. So Dickens really could have used this. Two of the important concepts that flow from these agreements that are relevant to you is firstly, the principle of national treatment, which basically holds that works originating in one contracting state must be given the same protection in each of the other contracting states as the latter grants to the works of its nationals. Okay, English. So you're in South Africa, you're working on a project here in South Africa. Let's say you're designing a building and you've engaged an Italian architect. South Africa and the Italian architects, or South Africa and Italy, are members of these conventions. The result is the Italian architects can rest easy knowing that his input or her input into the project, even though they're Italian and working in Italy, will receive the same recognition and protection in South Africa under South African law as a South African architect would, and vice versa. It's a two-way street. So that's a really important concept if you're working on international projects and have international collaborators. The second important concept I just want to touch on is the principle of automatic protection. This principle basically holds that protection must not be conditional upon compliance with any formality. This is particularly important in the world of copyright, and we'll address this a bit more wide just now. But again, it would be completely defeatist of the national treatment principle if our Italian architect now had to register here in South Africa before sending his information. So without doing the registration, he gets the benefit of automatic protection. But assuming that most of you are based in South Africa, I'm pleased to let you know that South Africa is a signatory to most of the major IP conventions, and that our IP system is actually considered very advanced, with the first piece of legislation coming out about 1916. So South Africa has been grappling with the concept of IP for over 100 years. And finally, South Africa is also considered a favorable destination for investors who are worried about protecting the IP when they arrive here.
Yeah, well, that's good to know. Thanks, Mark. And thanks to globalization, there's no doubt there will no doubt come a time, if it hasn't happened already, where a lot of the people using the BIM together with colleagues from all around the world. And so it's probably a good idea that everyone familiarizes themselves with their rights in the different jurisdictions. And of course, that's where, No one's asking everyone to become a legal expert here, but that is where your lawyers are really beneficial when you're engaging with people in different jurisdictions. So now that we know that we're afforded some protection when sharing information with international collaborators, certainly when engaging in a BIM environment, let's turn to the different categories of IP that are recognized in South Africa. You touched on this earlier and you mentioned that there's different categories that we should be aware of, and being able to identify them is quite important. So as I understand it, IP is categorized into 4 main categories, and those are trademark, copyright, patents, and design. Mark, am I right?
Yep, that's it. So I've just briefly summarized on the presentation what these are. Each of them has their own legislation here in South Africa, which they codify the concepts. I'm not going to go into too much detail around about how you recognize these rights, how you register them. I'm just going to touch on what you really need to know about them. So all you need to know, there are these 4 categories. Trademarks, I think we are all quite familiar with. The Trademarks Act defines that trademarks are marks which distinguishes one trader's product or service from a similar product or service of another trader. I mean, if we think of trademarks, you can think of the Nike logo. You know immediately that the Nike logo is different to the Adidas logo. That's the mark. Patents, which I have no doubt many of you are familiar with, is an exclusive right that is granted for an invention, which is a new method, a new product or apparatus, process or use that involves a new way of doing things or offering a technical solution. It creates a 20-year monopoly over that invention, and that's a quid pro quo principle that as the government, I want you to invent things, but at the same time, I also want you to be able to benefit from it. So I'm going to give you this protection. Nobody else can use your patent. Then you get design law. Design, I find, is easiest to describe if you think of the new BMWs. They've got that big grille in the front, nice big toothy grille. Whether that serves the purpose of cooling the engine, I'm not entirely sure. But then you talk about a functional design, nice big toothy grille to cool it, or they're just doing it purely for aesthetic reasons. And design law looks particularly at that and looks at the protection of the shapes, the configuration, and augmentations of an object. Then finally, and the most relevant for today's purposes, is copyright. Copyright, again, is a bundle of rights, granting the holder the right to do certain things. Can I adapt this, reproduce it, sell it, license it, distribute it, all these sort of things. With all of your IP rights, they're enforceable. They all work in the negative. Again, you stop people from doing things with it unless you authorize them to do so. In terms of patents, design, and trademark, you do have to register them in order to enforce them. There's an entire process to that. We're not going to get into it today. Safe to note that for trademark, there is a concept of common law trademarks that can be recognized. So if you haven't necessarily registered a trademark, you do have an ability to prove it, although your burden of proof is slightly higher. And then in terms of copyright, you don't have to register a copyright. In fact, 9 times out of 10, you can't. Copyright subsists in the work, but there are instances under the Copyright Act which you can register your copyright. It just goes to the evidentiary burden if we ever get into a fight about trying to prove it. And unfortunately, it's limited to things like films. So you can register your copyright in a film. Someone pinches it, publishes it without your permission. It's already a prima facie right that's been registered and you can establish. But what's important for us today is that we spend quite a bit of time considering BIM and Revit models. And it doesn't seem to us that the BIM and Revit model will fall into the categories of trademarks, design, or patents. Rather, it seems that they're going to fall into the wonderful world of copyright. So let's get into that. Okay, copyright isn't defined in the Copyright Act. Rather, we talk about trying to determine whether copyright vests in something. So to determine whether copyright vests in something, there's a 6-step test that has been developed. The first question is there a work? Is there actually something? Copyright doesn't vest in an idea. So you have a great idea one night, Cool. There's no copyright in that yet. The second you write that idea down, put in some sort of material form, suddenly the rights may occur to that. But the test in determining whether that work is actually a work for purposes of copyright is an objective test. We look at it, and then we apply subjective interpretations to it, such as the amount of effort, skill, and labor that went into creating that work. Arguably, and in our view, we've spent a bit of time looking at Revit models, and we're of the view that it's a work because it's an item that has been created, has required some sort of inventive step or labor and efforts and skill to create it, albeit it's a virtual thing, but it does exist. It's in some sort of tangible format, and there's been an effort made to make this thing. The next question in our copyright assessment is, does the work fall into one of the categories listed in section 21 of the Act? If you can't get your work to fall into one of these categories, it's out. You don't pass the test, you can't get your copyright. The Act actually recognizes quite a few categories. The most popular ones, the ones you'll recognize, are artistic works, literary works, musical works, sound recordings. But importantly, from a BIM and Revit perspective, the Act also recognizes literary works and computer programs. Now, I'll tell you why I say that's important. A literary work is defined in the Act as including tables and compilations, of data stored or embodied in a computer or a medium used in conjunction with a computer. We'll touch on some of the cases around databases a little bit later, but your key takeaway is that a literary work includes data in a table or data having been stored in a computer. And then the second category that these models could fall into is a computer program. A computer program is defined again in the Act as being a set of instructions fixed or stored in any manner, and which, when directly or indirectly in a computer, directs its operation to bring about a particular result. So it's got a set of instructions, you click on this, X, Y, and Z then happens. So you've got your data, underlying data, then you've got your set of instructions, and you've got the results. And the Act specifically recognizes those. So as far as we can determine, there hasn't been any case law before the courts in relation to BIM models specifically. Therefore, it will have to be tested. So if any of you do want to get into a fight, just realize that this is a bit uncharted. There are cases dealing with the recognition of copyright in computer programs and in databases and who owns what. In particular, the unauthorized use and adaptation of computer programs. We'll deal with that a bit later. But it is going to be a fairly novel case, and you'll have all of us very interested in seeing what actually comes out of it. Right, so then our third question in our test, remember it's a 6-step test. Is there work? Does it fall into one of these categories in the Act? Is the work original? Or have you just copied it from somewhere? Again, we look at subjective considerations of this. What sort of novelty have you put into it? Have you taken time and effort to create something new? As Baynes suggested earlier, to some extent, table is a table, a pipe is a pipe. Is this something new that you've done to a table or a pipe or a building that should be worthy of protection? Or is this something that's just common to the trade? It is in your university textbooks. Your parents had it in their university textbooks. The wheel goes round. Then the last 3 questions we have to deal with are more sort of formal legal questions. The really interesting ones are the first 3, because then we assess what the work is, apply the Act to it, and try to figure out whether this thing is new and worthy of any sort of protection. Then the last 3 are really technical questions, which might get lawyers quite excited, and we have fights about this, but I don't think you guys need to worry about it too much. I'll just touch on them very briefly. So our 4th question, does the work exist in a material form, or must it be reduced in material form? The 5th question is whether the work is immoral. Now, I know that sounds like an odd thing to include in a test, especially with law. You're thinking, surely we're not thinking about the morals of society. But actually, if you consider the entire basis for our law, it's to reflect the basis of the morals of our country. Look at our constitution. We've got concepts in there of Ubuntu, freedom, and rights. So this question has really been included within this assessment in order not to afford protection to things that are immoral or against the morals of the country and which ought not to be protected and promoted. So again, that's a nice constitutional law argument that lawyers will get very excited about. That's very unlikely any of you are going to come across that. Then the last question is, and again, going back to our international legal framework, is whether the person is made, whether the work has been made by a qualified person. All that means is, are you South African? Did you make it in South Africa? If you're not South African and you didn't make it in South Africa, are you a member of one of the convention countries in which we have the principle of national treatments and automatic protection, and do you fall into this category? So if you answer yes to either being South African here or overseas in a convention country of the treaty, you're good. You fall into the category of whether you're a qualified person.
Mark, I just want to stop you there for a moment. Whenever I'm engaging in a copyright-related matter, the legal team spend quite a bit of time considering who's the author and who is the owner. Can you perhaps explain to our audience why this is an important distinction which needs to be made?
Okay, yeah, fantastic. So this was touched on slightly earlier in the presentation by Baker Baynes. It is an incredibly important distinction. You're correct. There's obviously a benefit to being the owner, because you get this thing, you can now commercially exploit it, you can sell it, you can use it. Two terms you'll come across in this presentation are going to be licensing. Licensing is when you take that right and you rent it, for lack of a better word, to someone else. They can use it for a particular duration of time, for a particular purpose, as a project, particular area. You can only use this work in South Africa. And then you talk about assignment. Assignment is, I'm selling my rights to you, you have exclusive rights to it, do with it what you like, goodbye. So determining who the author is and who the owner is from a commercial aspect, incredibly important. And certainly from the poll earlier, there does seem to be concern around this. So the author is the person who first makes the work. There can be co-authors or joint authors. We see this often in academic publications where you recognize more than one person who got this text together. And importantly, not to panic everyone, the author can also be your employee. But the general principle then goes on to say, the owner, the first owner of the copyright is the author, unless an exception applies. So we know the owner is the person who can commercially exploit it and can benefit from the use of the copyright in that work. But in the employment context, your employee may be the owner, but an exception kicks in terms of which, if that employee makes the work during the course and scope of their employment with your company, that company is then the owner of that work. So,
okay, thanks, Mark. So really, the distinction of author and owner goes to the heart of copyright. Copyright is a commercial law concept, and like most things in the commercial world, is driven by money. IP, like any other assets, can be protected and commercialized. It can also be valued and used to obtain financing from banks. So think about the IP value chain in the BIM environment just for a moment. Autodesk creates software like Rivet, a computer program that can host data, and offers to sell it to you. You pay money to get the BIM software from Autodesk. That software is sold to you under license by Autodesk. And then there's a license agreement that'll say you can do X, Y, and Z with it. You then get engaged by a client to develop a project. The project requires that you use BIM and develop Rivet models. So do you sell Autodesk software to the clients? No. They engage you because they want a building. At the end of the day, you sell them a design for a building. But then what happens to the individual contributions that went into that design? Does the client get the benefit of all of this information? Do the architects retain their IP? What about the structural engineers? This all needs to be considered and defined in project scopes, licensing agreements, manufacturing agreements, and made subject to certain limitations, restrictions, such as the period of use and the scope of use, i.e., you may use it, but only for this project.
Yeah, absolutely. I mean, Kesha, as you know, we get a lot of clients coming to us and asking us to assess what the position is. And they often do this through due diligences. So they give us all their documents and they say, what is going on? I want to know the risks. So when we do one of these IP due diligences, there's a couple of things we look at. We try to identify what IP they're concerned about or where it's protected within all these documents. We look at what is being licensed. Remember, that's the rent, what's been sold, what's been signed. We look at the terms of use of the IP. Is it project-based? Do you only have access to this information until the project is completed? What is that completion date? For how long? Can you access this information after the project? Or have you bought the rights to this information indefinitely? Can you then use that information for anything else? What's the extent of your rights in terms of the use? Can you take it overseas and sell it to someone else? And then we also look at what the possible breaches are of these obligations and how that gets dealt with. So we'll actually go down a bit of a rabbit hole for the client, look at all these documents, and just try to identify what these risks are so that they can either tighten up or mitigate on these risks.
Yeah. And well, having regard to all the information that we've presented so far, if you remember nothing else, then just remember this. If you are the owner of certain intellectual property, your rights are protected even in the absence of a written agreement, and in some cases in the absence of formally registering those rights. The hurdle is having to prove that, one, you are the owner, and two, that your rights were infringed, by who, how, and of course the damages suffered, if any. So to fast track these type of disputes or prevent them altogether, it is actually advisable that you enter into a written agreement before proceeding with the project and expressly record your rights and obligations in respect of any IP. Of course, doing this means you have a better chance of avoiding disputes and infringements. And for that reason, Mark and I, being litigators who survive on disputes, considered leaving this part out of the webinar completely. But in the interests of proving that lawyers do in fact have a conscience, we've left it in. It's advisable that you appoint a lawyer to draft any agreement for you for use in a project, because there are many factors that must be considered in order to ensure that your rights are properly protected. And these will always depend on the facts of each case. So, for example, and as we obviously mentioned earlier, if there are people involved in a project from different jurisdictions, you would want to ensure that you record which law governs the relationship and consider the laws of each jurisdiction to ensure that you're aware of and manage any laws relevant to the jurisdiction which may impact on the enforcement of your rights. For this webinar, we intend highlighting a few clauses which are on the slide, and we think that these should be carefully considered when drafting an agreement relating to IP. So the first is the definition of confidential information. So these definitions are very wide. In fact, I've seen a definition for confidential information that took up an entire page. And in essence, confidential information is any information which a company has an interest in keeping confidential. Rocket science, I know, but these definitions should be carefully considered to ensure that any such information relevant to your particular business is covered. It's important to note that the impact, of course, of the Protection of Personal Information Act and ensure that confidential information pertaining to any aspect thereof has been dealt with. Then, of course, there's the definition of intellectual property. Again, these definitions are generally wide, but when considering a definition, you need to ensure that any intellectual property that you want protected is clearly recorded in the definition without ambiguity. Every right and obligation recorded in your agreements in respect of your IP will be interpreted in relation to this definition. And so it's important that the definition is correct and covers what you need it to cover. Because BIM requires the exchange of information and IP, it's important that the rules are set upfront for each user. Recording who the owner of the IP is and the fact that it cannot be copied or used outside of the relevant project is fundamental. You must ensure that the limitations of use are recorded and give consideration to the duration of the use, the purpose, what is required of the user once the project is complete. Do they get to keep the IP, for example, if they purchased it, or must it be given back and all copies destroyed? It should also be clearly stated that when it comes to companies, the company will be liable for any breach by any of its employees. So you can see from the slide that we have presented some examples of the type of wording you would want to see in your agreements dealing with IP. And in addition, as a company, you would want to ensure that your employment contracts clearly deal with the ownership of IP, including any IP which is created by an employee during their employment. Mark and I will be dealing with this in a bit more detail shortly, so I'm going to leave that employment aspect there for now. What is also important to ensure is that your any breaches of the relevant agreement and the consequences have been carefully considered and dealt with. So, for example, I've seen some agreements which include penalty clauses, and that requires a payment of a very specific sum of money in the event of a breach. It is also important to deal with how the relevant IP should be treated pending the outcome of a dispute relating thereto. So obviously, if somebody wants to allege a breach, what do you do pending a decision on who owns that IP? So this will depend on the relevant IP. But if, for example, the IP is required to be used by the other party, and withholding such IP would cause damage, it can potentially be agreed that a license fee should be paid into an interest-bearing account pending the outcome of the dispute. If the owner is ultimately correct, then the accumulated fees plus the interest must be paid over to the owner. If, however, the other party is successful in proving ownership, then the accumulated fees and interest can be paid to that party. My last point on this topic is that one should also consider the dispute resolution process very carefully and how this should be dealt with in an agreement. One of the biggest mistakes that we see is people using dispute resolution arbitration clauses in agreement that are very general without giving consideration to the parties' contract and their respective locations, the subject matter of the agreement. I think some people may think that it's not an important clause when they're trying to close a deal, but I can assure you that is a decision you may live to regret if a dispute arises and you are bound by that process. Having lived obviously through a pandemic, I know there was a lot of negative things as a result, but one of the consequences of the pandemic that I'm very grateful for is the impact the pandemic had on dispute resolution process. So prior to COVID, we would never have dreamed of running a matter virtually. But now, in my opinion, I think it is the preferred approach. In my experience, I've run both trials and motions virtually, and it has been much more efficient and cost-effective to conduct them virtually. And this includes a trial where the credibility of a witness was, in fact, key in our matter. When parties and witnesses are based all over the world, as may be the case on certain projects that you're involved in, it makes sense to agree to a virtual hearing because everyone can connect as and when they're required to do so from wherever they are. It saves a lot of time for everybody involved and it substantially reduces cost. Because remember, when you're running a case, you're required to not only pay for your legal team, but also for all travel expenses for any of your witnesses. And in some instances, you're required to compensate them for the time they spent out of the office. So it all adds up very quickly. And especially in cases involving different jurisdictions, virtual hearings should be considered and included as part of the dispute resolution process in all agreements. Remember that arbitrations are consensual. And so in the absence of an agreement, a party cannot be compelled to follow a process suggested by the other side.
Okay, so, sorry, I was on mute there for a second. Kesha, absolutely correct. Parties need to consider things very carefully, but often we find people are not quite so trusting of the black and white letters of the law. Yes, fine, you've got these acts in place, you've got these international conventions. Yes, fine, you've got these agreements in place, but things happen, you know. So what we've seen happening over the years is literally a spy versus spy situation. It actually started with the map makers of old. They would put a fake or fictitious town into their map or a mountain range. So that way, if they ever saw a map that had that town or that mountain range, they'll know that was a copy of their map. And in fact, there's quite a bit of literature on this online. If you go look at it, there's a couple in the States, I think just north of New York. More recently, there's actually a quite nice little trap set by the fax directories. Basically, what happened in this matter, fax directories went around and they compiled a database of all of the fax numbers. You know, for those who are slightly older, you'll remember the Yellow Pages. Basically, it was something like that with all the phone numbers and the contacts in the fax directories book. Unfortunately, SA Fax Listing perhaps didn't quite want to go through all of that market research, and what they did is they made a copy of a large part of the fax directories case, fax directories book, and one of the telltales that sunk them in the court case was that fax directories actually put in a few fake phone numbers, fax numbers. I think there's 21 of them, but there was absolutely no way that SA Fax Listing could have got these numbers because they didn't exist. So therefore, it had to be a copy of the fax directories case. When considering this in the BIM and Revit model, I also spent a bit of time researching it before the seminar. I came across quite an interesting online blog where this exact debate was being held with participants. And one of the suggestions was embedding a code, almost like a key code, into your model, so that if that model is ever taken by someone else who doesn't have that code, that model won't work. Now, these are all just little mechanisms you can consider if you really want to go to that extra length to put in this information to prevent potential theft or potentially identifying who the culprit is by saying, wait, that's my copy, I can see my fax numbers, or it's not working to my code. But it's important to note that one of the nice things about the technologically advanced environment we're working in now is that you're in a common data environment. You can control access, you can track who's done what, who's taken what. And this technology certainly excites us as litigators because we can see what has happened to that information, who's taken it. That gives us our blood trail to follow. Let's see what's happened with this information.
Absolutely, yeah. So, you know, you mentioned that you did a bit of research, and there's been quite a lot of discussion around this topic and within the BIM environment. And so, prior to this webinar, Baker Baynes reached out to some of their customers and asked whether they would like to submit any questions for us to consider and deal with during this webinar. So we're going to go into those questions, and obviously you'll see them on the screen, but Mark, I'll just take you through them, ask you the question, and of course you can provide us with your well-considered response. So the first one, who does my Rivet model belong to?
Okay, the question of the day, and I think why everyone is here.
Yeah.
So actually, funny enough, anecdotally at the gym this morning, I was talking about this presentation to one of my colleagues, and he's an engineer, designs piping. And his problem was that, you know, he learned about how to install piping many years ago in university. This information's in a textbook, but he often now finds on models his name is still being quoted and saying he's never had any interaction with. But what's happened is somebody's just copied his model and used it. So we need to go back to the very beginning of what we were speaking about in the copyright context. What are we dealing with? You'll remember that the general principle is that copyright vests in the author, and the first owner of the copyright is the author unless an exception applies. So when you're considering a Revit model, that needs to be your starting point. And you need to consider now what is in that model. So we start with the basic underlying information and the formats from Autodesk when we're referring to a Revit model. Then there's some standard design elements, like my friend at the gym this morning, talking about stuff he learned in university. And then there's going to be individual contributions made into that model by various collaborators. And then finally, you've got your model, who owns that? You will have to go through each of those components and apply the 6-step test from earlier. Is there work? Is it original? You know, all those 6 things. So we've gone through each of these steps and just taken a very high-level view. Certainly, in terms of the Autodesk information that's being given to you under license, it's highly unlikely you'll be able to assert a copyright claim over that.
Yeah.
In terms of the standard design elements, a pipe is a pipe is a pipe. Your 90-degree join, you know, it's common to the trade. It's not particularly new. It's not novel. Everyone kind of knows about this, and it's really required because of function. So again, unlikely that you'll find copyright vests in it. But now when you're talking about the collaborators giving specialized input where they have to problem solve, they have to apply a large degree of skill and effort into coming up with a solution for a particular problem that is unique or has some sort of value because no one's ever thought about this before. Now we're talking copyright and some protection. But you'll have to apply your 6-step test and see whether you meet all 6 of those requirements. If you do, then fantastic, you're in with some sort of protection. But what do you now do with that protection? Cool, you've got your copyrights, you know, so what? It goes into the final product. Then we have to look at what you spoke about, Kesha, in terms of the contracts. You know, assuming that the copyright does subsist, who owns what? Why did you give that information to them? What are you selling to the client? What is the client actually purchasing from you? End of the day, client wants a design, but do they want all that underlying data that they can then use for whatever purpose they like in the future? Or are you only allowing them to use that information for that creation of the final product? What are the limitations? So really, unfortunately, you know, a lot of these questions we've been posed with, particularly from an IP sphere and world, is it's all depends. It's going to be a case-by-case assessment as to what law it is and what contracts are in place.
Absolutely, thanks. And I think that's why it is fundamental for contracts to be, you know, secured before a project begins, because then you avoid all these uncomfortable questions and uncertainties. And, you know, when I mentioned earlier about the, you know, the interim period whilst you're having this debate, you've got this IP sitting and either it needs to be used or not, and what do you do? And so it's really important that these things are ironed out right up front to avoid great disappointment down the line. So yeah, thanks for that. The next question is, a service provider was appointed for project stages 2 to 4. During stages 5 to 6, the client provided the service provider's Rivet model to other consultants. Is this allowed?
Okay, going to sound like a broken record again. You know, 6-step test. Are there agreements in place? Why are you giving your model to another consultant? What is the purpose of that? For how long? Why are they using it? So let's assume that there's an agreement in place. Let's assume copyright subsists. And now you find another consultant has taken your model and is using it further on. You'll look at your contractual remedies. You know, arbitration, fantastic. It's a nice private process. You don't need to disseminate your information. But generally, your as with any good litigation, Kesha, you'll know your first step is going to be a cease and desist letter. You know, stop using my information, give it back to me. You're not allowed to do it. If they don't want to comply, then you look at an interdict. And that's an order from the court saying, don't do it. You can also then consider suing them for damages, saying, well, you got the use and benefit of this model, you weren't entitled to. I want some sort of payment in terms of damages. Or possibly, I see you put into an agreement, you've licensed it out to half the world, you're getting royalty fees for that. I want to cut, I want royalties for this as well. So there's a good couple options for you.
Awesome. And obviously also what we had touched on earlier is the dynamic between an employer and an employee, and you know, who the owner of any created content is. So this question is quite important, and I think a lot of people don't really understand the differences here and who's got the ownership. So an employee created some code or BIM content outside of office hours. The employee has left, but is asking to be compensated for creating the code or content. What is the position?
Okay, this is probably the clearest answer you're going to get out of me today, other than it all depends on a case-by-case assessment. All right, so you'll remember I briefly touched on earlier that in terms of the Copyright Act, for those who are writing notes furiously, at section 21 sub 1D, holds that if an employee creates a work in the course of the employment, then the employer is the owner of the copyright. But then from the question you've asked, there's a debate about, was it done in the course and scope of the employment? Now, there's a great case in South Africa. It's called King versus the SA Weather Service. Basically, I'll just run through what happened in this matter. But Mr. King, he was a meteorologist working at the SA Weather Service. And he realized he could create some code just to make his life that much easier. So what he did, at night, at home, with his own computer, he created this code that he then started to use in his work to make his life easier. I mean, he was a clever chap. I mean, it's a good idea. Who doesn't want to make their work more efficient and easier? A couple of years on, his employment was terminated. A dispute then arose because he refused to give the source code to the SA Weather Service to carry on using their code. He said that I have a tacit agreement in place with you. I developed this code, and you could only use it whilst I was employed. I'm terminating this agreement. I'm taking my code with you. The SA Weather Service turned around and said, well, no, you did this during the course and scope of your employment. It's our code. So this resulted fights that went initially from the High Court, then to the Supreme Court of Appeal. And the Supreme Court of Appeal was now stuck with the situation of trying to consider, what does it mean in the course and scope of your employment? So how do they assess this? Mr. King wasn't sitting at home at work using a work computer doing this, but it certainly was connected to his job. So first thing I looked at was whether the work, the code that Mr. King created related to the business of the SA Weather Service, which they found it did. Made his job easier, it worked on their systems. Then they looked at the nature and duties of Mr. King's employment contract and how this relates to the work in question. I mean, we don't want to find ourselves in a silly situation where Mr. King was actually an opera singer and wrote an opera while he was sitting at home. Sorry, whilst you're sitting at work for the SA Weather Service, now the SA Weather Service saying, well, that was in the course and scope of employment. No, that wasn't part of his duties in the employment contract. Yes, he might have been using company time, but it's completely unrelated to what the SA Weather Service did. And then finally, they looked at the causal connection between the existence of the employment relationship and the creation of the work. So they're based, lawyers get excited about a bit of Latin every so often, a conditio sine qua non, if not, but what for? So why did Mr. King create this? I mean, am I sitting at home creating code to use in meteorological assessments just for fun? Or am I actually doing it because of my work? The view was, well, Mr. King isn't doing this just for fun. He did it to make his life easier at work. So ultimately, in that sort of situation, the court found that Mr. King had been acting in the course and scope of his employment, even though he did it outside in his own time with his own computer, because he met those criteria. It was just that link to his business you couldn't escape from.
Yeah. And again, this is why it's so important to clear these up in your contracts, certainly, your employment contracts. Make sure that they are clear on who has what rights and who would own what. It just avoids a whole bunch of unpleasantries later down the line. Okay, then the next one, source code was used to further develop a model or Rivet template. The further developed model or template is much better than the original. Are there any IP issues with this?
Well, okay, yes, they're gonna be IP issues. This we can accept. Again, there's a nice South African case where they consider this, but the problem in this particular case was that a company engaged a software developer to develop a code for them. There wasn't really an agreement in place. There was a split in the partnership. The developer went and worked for partner A for a bit, and then partner B. And he eventually developed this code for these two separate businesses now. But when they both ran on the same system, there was a conflict in the code. They made each other crash. So the court was now in the position of having to look at this and saying, well, who owns the copyright? Where do I even start? You were both originally business partners. You didn't firm up in your agreement with the developer. Does the developer have a right to it as the original author and owner? To what extent did the business in the first instance have in developing this code for fit for purpose. So I'll just give you the reference to this matter. It's Haupt versus Brewer's Marketing Intelligence. It's an SCA case from 2006. And basically it is an advertising agency and the purpose of the code was to simulate information and then create an assessment of who the readers, listeners, viewers of particular magazines, periodicals, radio stations, and television stations were. Obviously, you can imagine from a marketing point of view of how powerful that is.
Mm.
So, here's the court now, having to look at this very technical piece of code developed by a developer, author, owner, but for a very specific purpose. And then, lo and behold, there's a split in this partnership. One of the guys goes off to the States, one of the guys stays here. They both use the same developer to carry on building the code. Who owns what? So it was all a bit of a mess. But ultimately, what the court found was that the developer was developing the code for the business initially. It wasn't ever the intention of the parties at the time, in the very first instance, when the two partners were still together, that they would use this code, that the developer would keep the code, it would be given to the business, be used for the business. Cool. So we now know it goes to those two partners before they split. But now what happens when they both go their separate directions? Well, the court had to try to figure out sort of additions, and there are two different trees now as to how this thing was developed to their own practicalities. And really that assessment relied on how much input each of those developers had into now further developing that code for their own individual models. So it's accepted the underlying code was the developers, and then for those other two models, the court has to do this assessment. And what the court found is that the one partner wasn't really hands-on and didn't put much input. So all that was happening was coming from the active partner, giving lots of input to the developer, down to the developer, up to the other guy. So they actually found that the partner who put in the most input was the owner of the code.
Interesting.
I hope that makes sense. It's a bit of a mess.
No, yeah, and I mean, as you've said, it depends on a case-by-case basis, and we could sit here and probably talk for hours and bore everyone to death with all the different permutations of IP and the different rights and obligations, but we're going to leave it there for now, and that brings us to the end of our pre-considered questions and our presentation, and we're going to now open the floor up to all of you to ask some questions. Of course, given the time available, we are not able to get to every question, so if we can't get to yours during this webinar, please complete the forms which will be circulated, I think, after this webinar, so that we can contact you and hopefully get to some of those questions.
Thanks, Kesha and Mark. I mean, you've even given me quite a bit to think about, and I guess as in business school, it's the same in the legal world. A lot of these answers are all, well, it depends. So it's in a case where you can just give this like blanket answer to every single question.
Actually, Yanni, that's actually that's how we protect ourselves. Actually, little insight there.
But I mean, you can't just go, who does the model belong to? Because every case is different, every agreement is different. So,
yeah.
But I'm hoping that it provided some clarity to our attendees today, and at least have given them some more things to think about.
Yes.
The contact details are up on screen again if you do want to get in contact with Andersen's, if you want more clearer, direct answers specific to your case or a case that you may have been involved in. I do have two other questions that I just wanted to ask. First being, I need to share my Revit model with other consultants, and this is for collaboration purposes most of the time on projects, but what are they allowed to use it for, Mark?
So Yanni, that's going to go to my question to you, in fact, is going to be, why are you giving it to them? So if you're going to limit the purpose or scope of use, you need to consider why you're giving it to the other consultants, and then formalize that in an agreement so everyone knows who that model belongs to and for what purpose the other consultants are allowed to use it.
Great, yeah. Thank you. My interpretation, my simple interpretation of that then to everyone online is that if you are sharing your Revit model with other consultants so that they can use it to coordinate, that is what they can use it for, nothing more.
Yeah, exactly.
One other question. Yes.
Sorry, just mention while you're on that. Certainly within the project scope and the engagement of all the consultants working in a collaborative environment, there should be put in place some sort of overarching consideration as to maintaining confidentiality, protecting copyright or intellectual property of all the parties, and that all remains in place for the duration of the project. At the end of the day, it's your client who's commissioned the project who wants to see an end result, and what it is that you're giving to that client. Are you really giving the client all of the individual contributions, or is it just the final product? Here's your design, go build.
Great, thanks. So to everyone, that is to keep in mind that you need to document these things, and not just do it on your own, but actually get the correct legal advice and make sure that all of your execution plans and protocols and contracts and things like that are drafted up correctly. I do have one other question that actually I think briefly relates to something that one of the cases that you've mentioned earlier, but it's something that we recently had one of our clients with a similar situation where an ex-employee left the company. They, whilst they were in employment with the company, they helped with the creation of a model or a template, and now they've left the company and they're using that model or template for whichever reason. What kind of action can we take if we see that ex-employees are using things that they created during employment with us? Okay, fantastic. So by now, I hope everyone knows the difference between owner and author. You're the company, we're assuming you're the owner. Someone's pinched your ex-employees using some information, and if they've gone to a competitor or using it for their own ends. Again, with all good things litigation, your first letter is going to be a cease and desist. If they don't, you can then consider more formal court procedures. You can bring an interdict to stop them from using it. You can ask for delivery up, so give me back everything that you've taken. You can sue for damages. You've lost corporate opportunities because X, Y, and Z. And then there's the royalties, which probably is not that applicable in this case, but certainly I'd be looking at cease and desist, interdict, damages.
Yeah, absolutely.
Great. Thank you very much. There's one or two other questions. As we mentioned, we can't get to all of the questions today, and I think a lot of the questions kind of follow very similar themes. So the contact details are there, and there will be some post-webinar communications that will go out. But thank you very much, Kesha and Mark. That was definitely extremely insightful.
You're welcome. Thanks for having us.
Yeah, from a closing out point of view, how can we help you? So, I mean, I think it's very clear how Kesha and Mark can help you. And one of the ways that I believe that Baker Baynes can help you is to facilitate these types of conversations, to put our audience and the people in our network in touch with different industry experts like we have today. But just more kind of from a tactical BIM and Revit aspect, the types of things that we can do to help you specifically around BIM and consulting are the implementation, looking at different strategies for model management. I could definitely tell you who the model author is and give some guidance around what type of things should be in execution plans and standards and protocols from BIM point of view. For Revit, if you're wondering back to, why are these people so concerned about their Revit templates? If you've ever seen a really, really well created Revit template, then you'll understand why some people definitely want to protect that. So Revit template, model health checks and so forth. And Mark did also briefly touch on common data environments and the collaboration, and how when you are actually using proper common data environments, there are luckily quite a bit of security settings and things in place to at least track where the pawpaw hits the fan if it had to. Yeah. So definitely in that aspect from a Baker Baynes point of view, training and some best practice around different construction workflow, security settings, that type of thing, we can also help you with. All of this is done in the context of our IADIP methodology, so assessing, and I think this is very similar to what we're seeing from Mark and Kesha, to go, well, if you present us with a question, well, first we need to assess what kind of situation are you in before we can actually give you those answers. So we follow assess, educate, consult process, where we look at both the people, the process, and the technology that has been used. Then just something, a little bit of a exciting new thing, at least I'm pretty excited about that, is Baker Baynes will very soon be launching our transformation tools. It's an online platform where people can consume multiple different pieces of content. So a lot of the webinars similar to the one that we're hosting today, and some of the other webinars in the series will be available. Ebooks on BIM implementation, best practices, that type of thing. And also things like the BIM content that we've spoken about today. If you don't necessarily have the time to sit and go and create these templates from scratch, that will all be available on transformation tools. So keep a lookout for that. That is coming soon. Then last but not least, for the almost 200 people who have stayed with us until the very end, and I think that's just because the content was so great, please scan the QR code. You need to do this in order to get your CPD certificate from a GIFA point of view. I think this is standard practice. You'll know that they need things like ID number, SACAT number, and so forth. So I will leave this on the screen just for a little while. And I think what I'm also going to do is to check with Amanda if it's possible to pop the link for this into the chat box on GoToWebinar. So in case CPD, I think it is actually already there. There you go. So if you are part of the generation that's used to phone books and not so much QR codes, there's a link in the chat box that you can just go and click on to complete this. So whilst I leave, I'll leave this on so that everyone can do that. I just want to again thank you, Andersen, for joining us today and for providing us with all of this information. I've already had a couple of people to go, will it be recorded? I'm going to have to listen to this a couple of times for it to really end. So thank you.
It's a lot to take in.
It is, definitely. But please get in contact with Baker Baynes if you need any assistance from a BIM point of view, or with Andersen's for any of your legal related questions. And thank you to GIFA for the CPD points for this webinar. And thank you for everyone who joined, and I hope you all have a lovely Friday.
Yes, thank you so much to Baker Baynes for hosting this as well and for getting us involved. We're really grateful, and thanks to all the participants. It was great to spend the morning with you all.
Great, wonderful. Cheers, everyone.
Bye.
Cheers.